Hello and welcome to the Indian Express. At the Indian Express, our mission is to foster independent thinking through well researched narratives and insightful perspectives. We believe in offering viewpoints that ignite dialogue and action, going beyond issues, highlighting to presenting practical solutions endorsed by thought leaders, industry experts, and sectoral visionaries. We are excited to introduce a unique and exclusive program tailored just for you, the dedicated brand fans who have made Express a part of their daily lives. It gives us immense pleasure to present to you news you can use in daily life, an engaging and insightful online masterclass series designed to provide you with practical knowledge and skills that you can directly apply to enhance your everyday life. Our first event was with Prashant Gautam, DCP of CyberSec, who discussed the latest phishing techniques used by cyber criminals and how to protect yourself from falling victim to these scams. He also shared tips on how to spot phishing emails and SMS messages and how to keep your online accounts secure. In our last event with Dr. Ambuj Roy, who's professor of cardiology at AIIMS in Delhi, we took questions related to the surge in heart attacks among the young and whether it was linked to the aftermath of COVID-19. And was lifestyle changes needed to introduce or reduce the risk of heart attacks? Today, we have with us lawyer Ratna Appnender, who works on gender and human rights, and she'll be speaking about 10 gender laws everybody should know, including the 2021 Karnataka law that made it the first state to provide 1% reservation for the transgender community, and the 2022 Supreme Court ruling giving unmarried women the right to seek abortion in the same circumstances as married women. I hand over to my colleague Apurva Vishwanath.
Thank you, Nandu. Uh, so the conversation on gender has been quite pronounced in the last couple of years, as we see. It's happened both inside the courtrooms, which has spilled over into national conversations outside. What we saw as a defining gender discourse in the last year was, of course, the debate around the same-sex marriage. The Supreme Court, a constitutional bench of the Supreme Court, heard the case, and the hearing was live streamed, so there was a greater influence of what was happening in the court in public discourse. Several themes on gender were discussed in courts. Many of them new conversations that people may not have been aware of, and to see this in a structured manner being debated in the Supreme Court was pretty much an eye opener. Apart from, of course, the Supreme Court did not rule in favor of, having same-sex marriage as a constitutional right. Uh, the court said it is on the executive's role to do this, and it's not really the court's job to do it. So that debate will continue in most likelihood. Like it's probably going to see another round of litigation, and it's a conversation that has only just begun. The other big discourse, of course, has been around abortion and what are the rights of women when it comes to termination of medical pregnancy. On this, India again has a very liberal framework on abortion. Unlike the US, where we hear a lot of political discourse around abortion, India has a 24-week limit for abortion. So up till 24 weeks, a woman can choose medical termination of pregnancy, of course, with the recommendation of a doctor or a panel of doctors, as the case may be. But this issue also, the question, when the question comes up as to what happens after those 24 weeks, right? This is again come back to courts and is being litigated more and more frequently nowadays. So you see a host of cases, say in the Supreme Court or the High Courts, where it is minors or even married women or unmarried women who are coming to court seeking the right to abortion. And how does the court react in these situations? It, of course, has to decide on a case-to-case basis, depending on the merits of that particular case. But what are the underlying principles that the court really applies in each case is something that courts are also still grappling with. Should there be one uniform rule for all of these cases, or should you go by what are the needs of that particular case itself? So should the court's ruling be different, say if it's a minor teenager who's moving the Supreme Court, or if it's a married woman who, along with her partner's consent, is seeking termination of pregnancy? these are all, issues that impact you and I personally, which our gender discourse is not limited to some textbooks or courtrooms, but what impacts our everyday lives. So we will talk about more of these issues today with Ratna Appender, who Ratna has vast experience in dealing with these issues. I'm sure she's represented some people who in similar cases. And so Ratna will tell us about many such issues today. Uh, Ratna, I wanted to start off with something that is, because we are also talking about women, and one of the big conversations is, of course, women in the workspace and the sexual harassment law. We are just coming off just a few years of the Me Too movement, which, despite the impact of the Me Too movement, right, it has only left us with more questions on how to take this conversation forward. So, if you could start by telling us what the law is, what is sexual harassment, what isn't, and just generally talk to us about sexual harassment at workplace.
Sure. Thank you so much, Apurva and Nandu. Thank you for having me here. So I'll just quickly begin, and since we don't have too much time, I won't spend too much time on each, but I'll just quickly go over the law on sexual harassment at the workplace. So to understand the law on sexual harassment at the workplace, I'll quickly just give you a little bit of history. And it's important to understand that as opposed to, say, criminal law on rape or other offenses and laws relating to women's rights, sexual harassment as a misconduct, as a wrong, was first introduced and conceptualized only in the 1970s. So that's fairly recent. And it was conceptualized in the US in the context of academic spaces and workspace. And in India, it was only in 1997, in the Vishaka judgment of the Supreme Court, that sexual harassment was recognized at the workplace, was recognized as a wrong. And this arose out of the Bhavri Devi case, which some of you all may know about. It was Bhavri was a worker in the Women and Child Department in Rajasthan. She was gang raped for stopping a child marriage. And out of this incident, there arose an understanding that women need to be protected at the workplace from sexual harassment and sexual violence. So I won't get into the Supreme Court judgment, but now we'll jump to 2013, where we have a statute, an act on prohibition, prevention, prohibition, and redressal of sexual harassment at the workplace. So this act is a comprehensive act which is applicable to all workspaces, public and private, organized and unorganized sectors, right? And this act lays out a couple of things. It lays out it defines sexual harassment, who can file a complaint, against whom a complaint can be filed. So I'll just go over each of these things, and I'll refer a little bit to the act, but I'll also just summarize the rest of it and the inquiry procedure. What are the rights of the parties? So the act defines sexual harassment in section 2N and section 3. It defines sexual harassment as any unwanted physical conduct or verbal conduct or non-verbal conduct of a sexual nature. So it's key to understand what is key in the definition is that it has to be unwelcome and it has to be of a sexual nature. So sexual harassment, all of us have a commonsensical understanding of what it is, right? And we know that it includes a range of acts. It could be physical contact or advances. It could be a demand or request for sexual favors. This essentially means say aggressive flirtation or trying to hint or make say coded remarks requesting, trying to get someone to enter into a sexual relationship with you. It could be a sexually colored remark. It could be showing or watching pornography or lewd memes or jokes in the office and in the workspace, right? It could also be what is considered a sexist or a comment that is derogatory to a specific gender. For instance, comments which say that women are not interested in working, they're only bothered about their clothes, or that line of comment, that also amounts to sexual harassment because it creates a hostile work environment for women. So the understanding behind this is that there are women in the workplace. If they are subjected to, so men and women are subjected to several forms of behaviors or conducts in the workplace. However, women are also subjected to sexual harassment at the workplace, and this needs to be recognized. This is a violation one of the right to equality and non-discrimination, but also the right to profession. It affects women's productivity and their right to a workplace that is conducive to them working. This is the understanding behind making sexual harassment a misconduct. And there is also, considering the dynamics of the workplace, the Act also recognizes what it calls quid pro quo situations, where there may be, say, a demand or a request by a senior, typically a senior male employee, to a woman who is under his supervision and control, trying to convince her to enter into a sexual or romantic relationship with him. And in those circumstances, there is always a threat, the possibility of adverse action being taken against her if she refuses him. Or there may be, say, a promise of a promotion or whatever if she agrees to him. So, considering the dynamics of the workplace, the definition of sexual harassment has been drafted. So, who can file a complaint of sexual harassment? The law recognizes that sexual harassment is inherently gendered. It takes place in a patriarchal society where women are subject to certain forms of discrimination and certain forms of behaviors and violence. And this is a continuum. And so, only women can file complaints of sexual harassment against men or other women, right? The Act, the respondent is gender neutral, but the victim, the complainant, is restricted to women. Now, there has been conversation about whether the victim should be made gender neutral or whether trans people should be included in the category of the victim. But as of now, the law is gender specific to women. A complaint can be filed against a man at the workplace. Now, it's important to understand that the complainant and the respondent, so the complainant need not be an employee. She can file a complaint in a particular workplace against a man who is employed there. Or if the complainant is an employee, she can also file a complaint against an outsider, not necessarily only against an employee, an outsider who she comes into contact with in the course of her work. And
so, Ratna, just so that I get this correctly, it can be, say, I can file a complaint against someone who doesn't necessarily work in my office,
yes,
but if my contact to that person has been because of my work, through my work itself, right?
Absolutely.
And also, I can say, for example, as a woman, file a complaint against a man at his workplace, because I've met him, at his workplace, right?
If you were sexually harassed in the course of your work, when you say visiting his office.
Yeah. So this can be, say, like a client or, some external party where I'm working with or things like that.
Yeah. And so connected to this is also what is a workplace. So a workplace is the physical office space, but it's also understood as the course of work. So like what Apurva was saying, if she goes out for a project or an assignment or a reporting assignment and is sexually harassed during that, just because she's not in the office doesn't mean she cannot file a complaint. It is because she's sexually harassed during the course of her work. Right. And now when we're moving to remote work, obviously remote work arrangements or work from home is also counted if you are subject to any of these acts or behaviors during the course of your work. So it's important to understand it as not as a spatial workplace. Right. So that's one. So now I'll just get into the process of inquiry. So a woman can file a complaint of sexual harassment. So also the Sexual Harassment Act envisions a redressal procedure where each organization having more than 10 employees has to have an internal committee. And if this is for the organized sector. The unorganized sector has a different mechanism, which I can get into later. For instance, say, for domestic workers or construction workers, or the sector where there are no offices and which is not formal organized sector, there is a local committee which is set up under the district administration, right, which is run by the government. But all other organizations, whether in the public or the private sector, have to have an internal committee. And a complaint is filed to this internal committee. The idea behind this is also to create more accessible redressal mechanisms. There's a recognition that it is not easy for a woman, and she may not want to go to a police station every time she's sexually harassed, and the police stations are hostile spaces for women, and the criminal investigation and trial procedure places a great burden on women. And so there is the idea was to offer an alternative, simpler internal mechanism where the woman can access redress more easily. And so the woman can file a complaint. The complaint has to be filed within a period of 3 months from the date of the incident. But there's also a recognition that typically sexual harassment is not just a one-off incident. It could also be a series of incidents. And so this 3-month period is calculated from the last incident. And there's also there's a recognition that it is difficult for women to speak out and complain about sexual harassment. And so the 3-month period can be extendable by another 3 months if the woman explains why she has delayed filing the complaint. So a complaint has to be filed to the IC. It has to be in writing, and it cannot be anonymous. So the IC cannot act on anonymous complaints. The name of the woman of the complainant has to be put on the complaint. But the IC ensures confidentiality, both to the victim as well as the perpetrator, where the IC members will not speak about it or make the complaint or the identities of the parties public in any way. Once a complaint is filed, the IC has two options which it can give the woman. One is an inquiry procedure and one is conciliation. Conciliation, if the woman wants to opt for conciliation, it's basically a process where the committee hears both parties and says that we're not going to conduct a full-fledged inquiry into it, but whatever this conduct is, it should be stopped, and they just reach a settlement, right? But an inquiry process is one where the IC records a statement of the complainant. If the complainant has any documents to submit to the IC as proof or corroboration to support her statement, she can submit that. They record the statement of the respondent. If either party has any witnesses, either to the actual sexual harassment, or if the respondent has witnesses to his defense, or to other circumstances, if the respondent wants to show, say, a motive or whatever it is, both parties can submit their documents as well as name witnesses who may be employed in that organization or maybe from outside. The IC has to examine all these witnesses and the documents, and the IC has to follow principles of natural justice. So if a woman makes an allegation of sexual harassment, her allegation will be tested, one, by allowing the respondent to respond to it in full. Whatever the allegations against him are have to be provided to him. And two, he has the right to cross-examine the victim. And since it's an issue of sexual harassment, there is also an option where the parties are they don't come face to face, and the respondent submits his questions for cross-examination to the committee, and the committee cross-examines the victim. But the committee has to follow principles of natural justice and allow a fair hearing for both parties. Now, what is evidence, and how does a committee come to a conclusion? Often in cases of sexual harassment, a lot of times there may be documentary evidence in the form of, say, WhatsApp chats, emails, phone calls, or there may be CCTV footage, right? There may be witnesses who may have witnessed the respondent behaving in a certain way with the complainant. However, more often than not, there is no other evidence, or what we understand as evidence in cases of sexual harassment and sexual violence, because it's committed when nobody else is around, and the nature of the act itself is such that it doesn't produce other evidence. It's not like a case of murder or cheating where there'll be documentary evidence, or there'll be a weapon, or there'll be blood stains or whatever, right?
Say for something like an inappropriate touch, there is no other proof that you can really bring.
Exactly.
What happens in those cases?
So the victim, the complainant's statement itself is evidence. So she doesn't need. And this is true even in cases of sexual violence and rape, where courts have for decades been saying that in cases of sexual harassment and sexual violence, the complainant's statement, the complainant's testimony is itself evidence. So evidence does not mean something external. The experience of her and the fact that she's saying it is evidence. Now, how is this tested? This doesn't mean whatever a complainant says, she will be believed, right? There are, say, investigation and courts have ways of measuring and testing a statement of a victim victim or a statement of a woman, where it is required to be consistent, there needs to be some sort of credibility for, and typically in through the investigation and court process or the inquiry process, when a woman is repeating her experience a couple of times, it's not that difficult to sort of figure out whether it's true or not, right? Where there shouldn't be contradictions in it there, and also she's subject to cross examination. So as long as the respondent has a right to cross-examine her on every aspect of her statement, and that is how her statement is tested, whether veracity of her statement is tested. Then maybe corroborative evidence. For instance, if she says this happened on this day at this time, there may not be direct evidence of sexual harassment, but you will be able to verify whether she wasn't present in the office building on that day at that time, whether the respondent was also there, right? And nowadays with like CDRs or CCTV footage, a lot of the circumstances surrounding the sexual harassment can be verified by technical and other evidence. But the actual incident of sexual harassment can be verified, or that often it's only the woman's testimony that can speak to that. So courts have said that that itself is evidence.
So, Ratna, because you've been on some IC panels and what is the advice that you would give to, say, women who may have, it's often unclear as well, right? You don't know for sure if this is something where you want to file a complaint about or you're thinking about it. So how does one go about that process? Is there something that you should consider before you file a complaint? Does this question creep in about what is the proof? I mean, you answered some of it about what kind of evidence might come into play, but what is it that, say, a woman should keep in mind when she's thinking of these issues?
So I think one is to first understand what sexual harassment is. And frankly, a lot of times, I think even with amongst women, there is a confusion between sexual harassment and other forms of workplace harassment. So not every form of harassment that a woman experiences at the workplace is sexual harassment, which is why it's important to understand the definition of sexual harassment and that it should be gendered in nature, right? If that same act a man can be subjected to the same act, it may not be sexual harassment. And
like
so
you have a bad boss.
Yeah, exactly.
Screams.
Boss who's shouting at every day, that may be wrong, but it's not sexual harassment. So that cannot come to the IC. The second thing is that I've seen through experience is that very rarely do women complain about one-off instances of sexual harassment. If something happens once, it's not very often that they complain about that. But I mean, which I mean, it may be a good thing or a bad thing. I'm not opining about that, but often it's a series of incidents, and it's also a context. So I think what women need to do I mean, if you want to file complaints, I mean, whether you want to file a complaint or not is frankly, it's a completely individual personal decision. A lot of times it depends on a host of external factors. Like women are thinking about what their family will say, that they need this job, it might affect it, maybe it'll stop, what will people think of me, there are too many other factors that go in. So that's completely like it's an individual decision. But I think if you're writing out a complaint of sexual harassment, the actual allegation needs to be clear. A lot of times women talk about, and which is understandable, a lot of times the focus is on how it made them feel. It made me feel uncomfortable. Now that's not, I mean, I get where it's coming from, but that's not a complaint of sexual harassment, right? You have to say what the other person did in a way that shows that it amounts to sexual harassment, and you need to be clear. And I think that's what I would say in terms of like evidence and stuff. If nowadays a lot of like, there may be proof in the form of WhatsApp chats or emails or other stuff. I think everybody knows that you just have to collect it, and that can be used to corroborate what you're saying.
Can we take a question from one of our audience? I think we have Vaibhav Saini from Delhi.
Yeah, hi, I'm here. Yeah.
Go ahead, Vaibhav, ask your question.
Yeah, so I just wanted to know, like, since like all the divorce laws in India, like presently they were made, pastly they were made because of the taking woman-centric approach, because so being a patriarchal society. But right now it seems like there are more women, like they are basically misusing it, some part of Like in the major cities, we have seen that there have been cases where they have been misused. So, like any of the study has been done there, like your team is planning it out or something, so that we can have it like they are more gender equal now. So since like the past has gone, like we are in the future right now, where we
Mm.
have like they're both of them are going through in the divorces. So, but they're more woman centric, all of them. Obviously, Dory is
Mm.
like obviously is a woman centric approach, but majorly divorce laws also like when they have to provide the compensation and everything. Like I have seen my some of friends going through it, so that's why.
Mm. Yeah, yeah. So yeah, I think everyone has like anecdotal evidence, and like everyone hears of like laws, especially I guess I think you're talking about 498A, if I'm not wrong, right? Being misused, or like maybe provisions on maintenance, etc. So I think it's a slightly more complicated issue where so when you said studies, there actually have been studies, or like say women who work with the one-stop crisis centers or crisis intervention centers, and even studies of court judgments at like a trial court level, where they found that women use, or like the complaints under 498A often, which are filed at the behest of lawyers or at the behest of police. A lot of times complaints under 498A are filed because as a in some sense to negotiate, because the woman is not say she needs maintenance, say she's been thrown out of the house, or she's been abandoned, or her husband is treating her with cruelty, or she wants custody. These are the general issues that women have in marriages, right? Or she just wants a divorce. And when that process doesn't seem to be working, there are instances where 498, which is the section on cruelty, may be used. Now, I mean, of course, it's not right to use it as a negotiation tool, but when you see it in the broader context of the system not working, it sort of makes, that's probably why it's being used in this way. But and the second part of your question is whether these laws should be made more the laws itself, that I mean, I don't know whether there's enough evidence of say society changing. Like patriarchy still exists, the society still is extremely patriarchal, so I don't know whether these cases where the law is supposedly being misused is sufficient to say that the laws themselves should be changed, right? And there are anyway like a lot of safeguards now against arrest under 498A. More, I mean, the police never arrest now under 498A unless like it's in extreme situations. There are Supreme Court judgments on this and stuff.
Also, if I can add, Vaibhav, that one of the studies that I often refer to is by data journalist S. Rukmini. She specifically looked at rape cases in Delhi courts because we so often talk about a false rape case, right? So Rukmini examined a bunch of judgments in these rape cases to understand where are these or what are these false cases. So what we would say is, say a woman has filed a complaint of rape, and before a judge, that is before a magistrate, she goes back on her statement and says, no, no, this was a consensual relationship. The common term that is described for these kind of cases is it's a false case. The woman has filed a false case. But that's sort of a misnomer because what Rukmini's study found is that these cases were filed at the behest of the parents of the girl, because it would have been a consensual relationship to begin with, but where the parents want to regulate these relationships, right? In that sense, like what Ratna was saying, we're still a patriarchal society. We still have family controls on personal spaces and relationships. So where parents do not agree with such relationships, the instinct would be to file a rape case against the boy, which would have a direct impact on the relationship itself. And you would see this happen, especially in intercaste and cases where, say, if the girl is less than 18 years of age, say she's 17 and the couples run away, this sort of exercise happens very, very frequently there. So there are some studies which say that what we typically understand as fake cases or false cases are not really that. These are more nuanced conversations there.
Yeah, I think that's important. And also, there's a difference between a false case and a case where there's no conviction. right? So if there's no conviction in a case, does not mean it's false at all. Actually, a lot of the cases in which there's no conviction is because the police conduct investigations so poorly that the court can't convict, or for a host of other reasons, or the woman is sort of threatened to go hostile and whatever. There are a series of reasons, but I think we need to think about, when we say there are many false cases, what is the basis for that? How do we know, and what is a false case?
Uh, can we take one more question after this, and then we'll go back to our conversation on. Do we have Nipun Kant here? Nipun is from Patna. He's a student of Patna University, and he has a question. Nipun, can you hear us?
Good evening.
Good evening. Please go ahead with your question.
My question is that don't you think there is a lag in the society about these laws which you are telling, and especially the laws which were for the women? And if they are working in the organized sector, then they know their laws, what they should do and what they should not. But what about the unorganized sector, and how these unorganized sectors, women, those who are working in the unorganized sector, will take steps ahead to move freely without hesitating?
Yeah, that's a very important question. I wasn't getting into that so much because I thought we didn't have time, but I'm glad you brought it up. So there is, in the unorganized sector, there are multiple challenges, and also the frequency and the vulnerability of the women is much greater in the unorganized sector. One, because it's unorganized, there's no security of employment. They are come from a class where they're much more dependent on that everyday, the daily wages, right? So the kind of sexual harassment and sexual violence they experience in the course of their work is, one, much more serious. Two, there isn't as much awareness. Only there are some instances now where, say, civil society groups or unions are working with groups of domestic workers or women construction workers or brick kiln workers to increase awareness about the existence of this redressal mechanism, and also facilitate their filing complaints with the LC. So for women in the unorganized sector, they have two options. One is to file a complaint with the police, which again there are a host of challenges, or to file it with a local committee. The local committee, again, in a lot of districts, of each district has to have one local committee, but in a lot of districts it's either non-existent or it's dysfunctional, or people don't know about the existence of it. And so there are cases where, say, labor unions have helped women file complaints with the local committee, made it work, but I think that's still a process. It is nowhere as the compliance or awareness is nowhere close to the organized sector or the corporate sector.
Ratna, we were talking about, the process of making a complaint itself, what is counted as evidence and what isn't. If moving, are there any closing thoughts on sexual harassment at workplace, and then we'll move to other.
Yeah, so the only closing thought is what I was saying now, which that for an act of sexual harassment in the workplace, one is the remedy, the redressal mechanism provided under the act. The other, and there may be many reasons why women may still want to go file complaints with the police, right? They may not trust the internal committee. They may feel it's grave enough for them to go to the police. They may feel comfortable going to the police. So using that, I'll just go to the IPC and the sexual offenses under the IPC.
So if someone feels that their organization may have not been so objective and supportive, or if the internal committee itself is, say, not doing its job properly, there's no objectivity in how it's conducting its procedure. So then the other option is for me to go to criminal law.
Actually, and actually the woman has two options. She doesn't have to choose between the internal committee and the police. She can actually file complaints with the police and the internal committee. And the IPC also recognizes sexual harassment as an offense. So it is a criminal offense as well as a misconduct under the Sexual Harassment Act. So now I'll just talk about the sexual harassment under the IPC. And I'll also talk about other sexual offenses and rape. And I will be using the sections in the IPC, not in the new one, because it's just, and also
still in the IPC regime.
Yeah, and all judgments refer to those sections. So I thought it just makes more sense. So in 2013, when the Criminal Law Amendment Act was introduced, certain new offenses were introduced in the IPC. Before that, there was Section 354, which was outraging the modesty of a woman, which required criminal force to be used against a woman, which is basically molestation. But it still required physical contact, it was basically molestation short. It was not rape, but it was, say, sexual violence and molestation. Right. But in 2013, certain new offenses were introduced. One of it is sexual harassment, which is exactly the same. It's defined in the same way as it is defined under the 2013, the Sexual Harassment in the Workplace Act. That has been introduced as Section 354A. Some other important provisions have been introduced, which is disrobing. So these new provisions were introduced taking into account the actual experiences of women and the continuum and the different kinds of sexual violence faced by them, as opposed to just having molestation and rape at the other end. So offenses like disrobing, which is basically removing a woman's clothes, and this happens a lot, especially in, say, as a form of punishment and as a form of derogatory treatment to women belonging to the scheduled caste and scheduled tribe communities, right? So disrobing has been treated as a sexual offense, and this is a very important recognition that this is also something, this is a form of sexualized gendered violence. Another offense that's been introduced is voyeurism, which basically means either looking at a woman engaged in a private act when she's naked or she's in the bathroom or engaged in a sexual act, or capturing it on a phone or capturing an image so sort of capturing or looking or spying on a woman who is engaged in a private act, right? Then stalking has been introduced as a separate offense. Stalking is not just physically following a woman, but it could also be monitoring her through the internet or on social media. It could be attempting to communicate with her. And the condition that defines stalking is that despite the woman showing a disinterest, if the man continues to try to foster personal communication or try to foster contact with her, that is criminalized under the IPC as stalking. And the 2013 Act also amended the definition of rape. So before 2013, rape was defined as peno-vaginal intercourse against the consent of a woman. What the 2013 Act did is that it expanded rape from just peno-vaginal intercourse to any form of penetration, either into the vagina or the anus, or oral penetration, either with the penis, an object, or fingers. And this definition has been constructed out of a lot of testimonies and experiences of women where it became obvious that sexual violence is not committed only as peno-vaginal intercourse, right? Where there are, especially during conflict and like during communal violence, there have been cases where rods have been put into women's vaginas, where bottles, other objects are used. And so to understand rape as this entire category of acts. The other thing that was done in 2013 is that a definition of consent was introduced. And consent, so for a sexual act to be consensual, the unequivocal consent, voluntary agreement of the woman is required. Before this, a lot of times in the way courts interpreted, courts adjudicated on rape, often they presumed or assumed that the woman consented to a particular act and acquitted the perpetrator based on a number of factors. For instance, the fact that there are no injuries on the woman's body. So when we say there are no injuries on the woman's body, it actually just means that she was not also physically harmed, right? But that absence of injuries is read as her consent.
Yeah, and that she didn't resist, essentially.
Yes, that she didn't resist. And so the law and judgments now are saying the mere absence of physical resistance does not mean she consented. There may be many reasons the woman didn't physically resist, but it still may not be consensual, right?
Because it could be under coercion or fear, any of those circumstances, and doesn't necessarily be proof of consent.
And secondly, even if she does physically resist, you don't always sustain injuries. Like the World Health Organization has done a study which shows that only in 1/3 of rape cases are there only 1/3 of rapes lead to physical injuries. So this whole idea that if a rape happens, there will be medical evidence, there will be physical injuries is really a myth, right? So so the definition of consent was introduced, and so there's also a category of aggravated rape which has always existed, but certain new uh, sections, new subclauses have been introduced in 2013. And so there is a recognition now in the statute that rape in certain circumstances is aggravated. So just rape is where there is sexual intercourse without the consent of the woman. However, in certain circumstances, it becomes aggravated. And this depends on, and it can get aggravated depending on who the perpetrator is. For instance, if the rape is committed by a police officer, or a armed officer, or say the superintendent of a jail or of a shelter home, or rape is committed during communal violence or other caste conflict, right? Or rape is committed on a disabled woman, or it's committed on a child that's under POCSO. But in these situations, there's a recognition that the woman is much more vulnerable, and also possibly is cannot resist even as much as she could to other rape, right? Like if it's a police officer and if it's an armed person, the question of resistance doesn't come into the picture, because you're not going to resist at the cost of your life. So there is the category of aggravated rape. Now I'll use the scope of rape to talk about marital rape, and then get into the violence against women in intimate relationships and in the domestic sphere. So, as y'all must be aware, that despite several amendments in 2013, the exception in Section 375 for marital rape still remains. So, 375 defines rape, but it also has an exception which says that this shall not be applicable to a man having sex with his own wife, right? And this has always been, in principle, this has always been a contentious issue. In 2017, a petition was filed in the Delhi High Court challenging this exception. The argument being that even a married woman, a woman can be raped by her husband, and marriage is not a license to rape, and consent continues to matter. Now, there are different ways of looking at this. One is that in the Delhi High Court gave a split verdict in 2022, and now the case is before the Supreme Court. But we also just need to understand the entire context here. So while Section 375 of the IPC contains an exception to marital rape, we also have Section 498A, which which defines cruelty in the domestic sphere, cruelty by a husband on his wife. And cruelty includes physical cruelty, emotional cruelty, as well as sexual abuse, right? Sexual abuse or rape is also a form of cruelty. So in that sense, there is this section, there is a option under criminal law for women to file complaints of rape by their husband. There is also the Domestic Violence Act, the Protection of Women from Domestic Violence Act, which came into force in 2005. Which recognizes different forms of domestic violence. It recognizes physical abuse, sexual abuse, verbal, emotional abuse, and economic abuse. Now, sexual abuse here too is much broader than just rape. It says any conduct of a sexual nature that abuses, humiliates, degrades, or violates the dignity of a woman. So a complaint of rape can be filed against a husband under the domestic violence. There is an option for women to file a complaint. I think the debate on marital rape is that though there are options under the IPC and under the Domestic Violence Act, the fact that it remains an exception under 375 is violative of equality, and it creates a category of married women and other women. Now, the other side to this is, and one of the judges in the Delhi High Court judgment said this, is that marriage is inherently a contract which includes a sexual relationship. And so the sexual relationship is implicit in the contract of marriage. And so this classification is justified. Now, so I guess we just have to see what happens to that.
I want to talk about the Domestic Violence Act particularly because that somehow seems to be the source of concern about potential misuse, or like we discussed earlier, there's a lot of anecdotal references to, oh, we knew someone who misused this law, right? So talk to us about what the Domestic Violence Act is and what are these fears about misuse of the law.
Yeah. So the Domestic Violence Act was introduced in 2005. Again, until then, there was only Section 498A on cruelty, and there was Section 3, still is Section 304B, which criminalizes dowry death. But these two sections are one criminal law provisions, and there is underlying the women's movement's engagement with law reform. There is this understanding that for women, access to the law, access to redressal is most important. These provisions being there on paper in our criminal laws, where which forces women to go to courts or to the police station, may be ineffective because it's not accessible to women. And also, there's a recognition that in intimate relationships, when this violence or this abuse is being committed by the husband or by a partner of a woman, they may not necessarily want to send him to jail, right? And so that may also be a deterrent from them approaching the criminal legal system. And so the Domestic Violence Act was envisioned as a mechanism where the woman can go and complain and ensure that this abuse and violence stops. And sure that, and also it's not just physical abuse that the Domestic Violence Act covers, it's also things like economic abuse, which means not giving money, economic deprivation, not giving the wife money for her children's school fees, not giving her money for household expenses. Or it could mean you're right, it's a range of things. Or if there's physical abuse, the Domestic Violence Act also provides for, say, protection orders, where the husband is either not allowed to come into the house, or there is some sort of protection given to the wife. So the Domestic Violence Act recognizes the exact nature of violence that or abuse that takes place in intimate relationships, particularly marital relationships, but also others, say the abuse a woman can face from her parents, right, or her father. That kind of
how does we talked about relationships in marriage, right? Like if it's a marital relationship, how the Domestic Violence Act applies. What about relationships which are similar to marital relationships, say somebody in a live-in relationship, for example? How does the law apply to them?
So the live-in relationship categories become more common now, but this actually arose in, say, 2005, where there are certain rights that women who are married get, right, to maintenance or to custody or to alimony or property, etc., or even to be able to file a domestic violence case or a case of cruelty. But the lived reality in India is that not every marriage is either registered, and there are also instances where people there like men are married to more than one woman, right? And a lot of times there were instances where Hindu men who are in 2 or 3 marriages would try to deprive the second and third wife of the rights arising from this marital relationship. For instance, in this case, Veluswamy versus Pachiyammal, Velusamy had married Pachiyammal, but he was already married before. And this is quite common right across the country, where men marry more than one woman. And then he abandoned Pachiyammal. He tried to, when she filed for maintenance or alimony, he tried to say that I'm already married. This marriage was anyway not valid. And while the law under Hindu Marriage Act, a second marriage is not recognized, court said that even though the marriage may not be valid, the woman can't be deprived of her rights if the relationship is in the nature of marriage. Now, what is a relationship in the nature of marriage? It may not, And so for this, there are certain tests that courts have evolved. One is the duration of the relationship. It can't be too short term. It should be over several months or typically several years. Two is if they lived as a couple, this needn't be full time, right? It could be even like if the man is living with two women, but there is a substantial portion of time he does live with the second wife. Three is that they have to share a household, that they live together in a common household. They shared finances. they shared domestic chores, they had a sexual relationship, they may or may not have had children, and also there has to be an intention to treat this as a relationship, as a marriage. So these are the tests that courts apply in deciding that a relationship is in the nature of a marriage, even though it may not legally be recognized as a marriage. And now these same standards are applied to recognize a live-in relationship. And
so it's not as if, every relationship can be construed as a live-in relationship. There's sort of like a checklist which you have to run through,
yes,
to assess something, is a live-in relationship or not. Say
yes,
somebody, I've met for the last 2 weeks and we've had a relationship, that doesn't automatically become.
yes. Typically, you need to live together over a period of years, and there has to be an intention to sort of like,
Yeah.
have this stable relationship.
So, since we're talking about live-in relationships and the rights from these in these spaces, we take a question from Dr. Raksha. Raksha is an assistant professor in Delhi. So, Dr. Raksha, do we have you here? Another question. This is Neeru Batra who's joined us here. Let's take the other question first, and then maybe we can try and connect with Dr. Raksha. Ms. Batra, go ahead with your question. Can you hear us?
I had posted a question that I've understood a lot about the laws that you've discussed just now. Like, there's always been that a law is promulgated and its, applicability on the domestic life or work life of women is implemented at a much later stage in organizations or is seen in society. So how I mean this gap is being dealt with? I mean, is it only through the non-profit and non-governmental organizations that people take redressal, or I mean there are other ways where if we want to help out other women, how to start the process with them? Like I see so many domestic helps coming in, and I see they are like earning meager income despite all are working in the family.
Yeah.
They have to stretch against working hours in
Mhm.
order to be in work, and a lot of stress I see in women who come as domestic workers. So how to safeguard yourself in the process and also take up their causes? Do we refer them directly to certain organizations? I mean, that's because I feel there's a lot of stress even on the person who tries to help.
Yeah. So just to answer your question, one is, I think the essence of your question is that laws exist, but they're not always working. And what about implementation?
Yeah.
So that has always been a problem. I think it's only through years and processes that laws will actually be implemented. But it's also important to know that some of these laws recognize that there will be a problem in that they may not be implemented. For instance, the Sexual Harassment Act has a provision which says that if a company does not have an IC or does not comply with any of the provisions of this act, they can be fined up to 50,000. Right? So companies or organizations are forced to comply. Again, in the corporate sector, with their annual report, the Companies Act also has a corresponding provision. So there are ways in which there are checks and balances, ways in which you can force companies and organizations to comply with these laws. On the other hand, the Indian Penal Code, a typical problem with accessing the criminal legal system is that, especially in rural areas, especially if the victims are from, say, the Dalit or other marginalized communities, is that the police simply refuse to register an FIR. And that has been a problem for decades, which means that the investigation, the process doesn't even begin, right? And they're thrown out of the system from that stage. So in 2013, a section was introduced, Section 166A of the Indian Penal Code, which makes it an offense for the police to refuse to register an FIR if it's in a case of if in cases of sexual offenses. There's also the Lalita Kumari judgment of the Supreme Court, which makes it mandatory for an FIR to be registered. The police cannot take their own time or decide whether they want to register an FIR or not. So there are both like statutory and legal other things. And then the Domestic Violence Act, it has it's not really a penalty, but there is a mandate that an order, interim order, has to be passed within a period of 60 days, because typically in those cases, the urgency is, I mean, the matter is very urgent, right? And like delaying it defeats the purpose. So in terms of, yeah, but otherwise in terms of accessibility, I think it's a longer process where then it needs to be awareness, accessibility to be able to access these mechanisms.
We'll take another question. This is from a student in Delhi, Dhaneshwar. Do we have Dhaneshwar here?
Yeah. Am I audible?
Yes, please go ahead.
Okay. I feel that there is cognitive dissonance regarding gender equality. We oftentimes say that we are sensitive towards gender issues, but in reality, rarely do we follow that notion. Is current male-female generation in India gender sensitive? If not, what do we need to do? Lastly, in this regard, what are your thoughts on recently released movie Ranbir Kapoor starrer Animal movie actually? As a society, we are moving towards back, or is it purely artistic expression?
Apurva, you can take this
I
question.
think
I haven't watched it.
I haven't watched the movie either, but I think let's keep the movie review out of this conversation. The question, if I can just distill it, is essentially that while we say we are, sensitive towards gender issues, rarely is that really followed. We still do see all the injustices in the society. And I think the second part of the question was, but is the current generation changing? So I think that's again very speculative. So I will leave that out of the question. But if you can just take the first part of it. Again, that's one of the questions which points towards implementation, right? Do we really see enough convictions in rape cases? Why do we not?
So I don't know whether we can measure like the success of anything like with convictions and stuff, but
Yeah.
I think just the fact that we're having more conversations, that more people are thinking, like men and women are more thinking about these things, and there does seem to be a general like more awareness about, say gender and like these kinds of, I don't know whether it's sexual harassment or sexual violence or other things in everyday public spaces, in the media, in public discourse. So I guess that's it. It's the beginning of the process.
Yeah.
Yeah.
But one thing I wanted to ask you, Ratna, is when you look at data, right? When you look at the National Crimes Records Bureau, every year we see headlines like, Delhi is the most unsafe city, the most number of FIRs when it comes to sexual violence. And, this is the percentage of cases where it results in a conviction or an acquittal. How does one view these numbers and statistics? What does it really, because I'm sure you've seen this from close quarters, that the process in courts is a very complex one.
Yeah.
Oftentimes the result, even if there is no conviction in a rape case, that may not be in the best interest of the complainant as well, for the
Yeah,
complainant
exactly.
pursued it for so long. So how does one view these numbers and
I think
statistics?
one is that when we say like this crime rate is increasing, actually the rate of reporting is increasing. The crime rate may not be increasing. These crimes, we actually don't know whether the actual incidents of rape are increasing. Maybe people are reporting more and more, which is actually a good thing, right?
Yeah.
That's one. Two is that when we actually we need to study these FIRs right now, like you'd mentioned it earlier in the conversation, 90% of FIRs under Section 375, which is a provision on rape, are either what we call promise to marry cases, or cases where the parents of a girl file a case against the girl's boyfriend because he's either from a different religion or a different caste, right?
Yeah.
And now we have different like special laws on that, criminalizing intercaste and interreligious relationships. So a substantial portion of cases under 375 are actually these cases which are not rape as we understand them. And if these cases, say for instance, a case filed by a parent of a girl is resulting in an acquittal, it's actually a very good thing. So we can't again read acquittals as a failure.
Yeah.
Yeah.
It's actually protecting that relationship, which is consensual to begin with. So it's not necessarily a bad outcome.
Yeah. And a majority, so the what we need to think about is why are, see, it's like this, it's almost as if the criminal law is more accessible to parents, the family of a girl, as opposed to women who may actually be experiencing rape. There is also a general understanding that a lot more rapes happen than those that come to the police station, the court, right? So women who are actually experiencing rape and sexual violence still feel the legal system is hostile, do not want to come forward and complain, but instead the section is being used by, say, other interests. Yeah.
Yeah. Um, Before I let you go, I think this is, a question that I see even in the comments here. One of the most asked questions. Speak to the concerns about, if marital rape is the immunity for marital rape is removed, or what are the concerns, or because there is this whole debate about will
Yeah.
that lead to misuse, how do we protect men from these cases. It's just from, because like we've already spoken about what is evidence and how courts evaluate it. There are checks and balances, but tell us about what are those checks and balances and how does the system really work.
So I think when people, yeah, I see the fact that say Section 498 or certain provisions are used, even though those cases haven't happened, like it may be undeniable, but I think a lot of this is at the stage of filing an FIR, where, and not typically I mean, it doesn't, these cases don't usually go through trial. An FIR is filed and then it's used as a negotiating tool. So in terms of how do you safeguard your rights, I think if marital rape is, say, if the exception is removed, the court or the legislature will have to introduce certain safeguards where they will say, either like right now under 498A, courts, the Supreme Court has issued direction saying do not arrest mechanically, right? Do not arrest if a complaint is filed. It's only, and even, I mean, in cases we've done, it's very difficult to get the police to register an FIR also under 498A because they do preliminary inquiries in 498A. So I think, so the safeguards, I don't think it can be at an individual level. It
Yeah.
has to be in the law itself, where if
Yeah.
a certain provision is prone to being misused, things like requiring the police to conduct a preliminary inquiry or not arrest, right? Or those kinds of things should be there.
Which are already, inbuilt in other legislations that we see, right? It's not as if it be unique to this one aspect of
Exactly. Like, for instance, in a corruption case, you have to do a preliminary inquiry before arresting. So these things do exist. Maybe they can be used in these instances also.
Thank you so much for your time, Ratna. This was a wonderful, informative session for a lot of our viewers here. And thank you for patiently taking a lot of questions. And I do hope you get the time to watch Animal sometime.
Thank you. No, thanks for being here. And thanks everybody for attending and for all the questions. Thank you.
Thank you so much.